Retirement accounts. Distribution rules are complex. As the amount of money stashed in 401ks and individual retirement accounts has grown, more and more families are finding themselves locked in battles over who has rights to the assets. Even with the many concerns over retirement accounts in America, it's undeniable. IRAs and 401ks represent a lot of personal wealth for everyday Americans. That means retirement accounts are assets uniquely worthy of particular attention, to include when it comes to their role in your estate planning. Indeed, amongst households with at least $100,000 to invest, 60% of the household's assets are in an IRA or 401k. So, how ought retirement accounts factor into your estate planning? Who will inherit them? The answer is not as simple as you may think. Truth be told, the problem with retirement accounts is the crazy quilt of laws governing their distributions, and moreover, different laws apply to 401ks and IRAs. The inheritance of retirement accounts is a lively topic, and none other than the Wall Street Journal has recently offered a piece on the issue. While I commend the full article to your reading, let's review a few of the highlights here. With 401ks, the overarching rules are in place thanks to the Federal Employee Retirement Income Security Act, ERISA. If you're married, the 401k automatically passes to your spouse and does so regardless of whether your spouse is designated beneficiary, unless your spouse waives his or her right to your 401k. By the way, if you have a premarital agreement, your intended spouse cannot effectively waive rights in your 401k until you are actually married. Plan accordingly. What if you have children from a former marriage and you want to include them as beneficiaries along with your new spouse? Consider rolling your 401k into an IRA and making the beneficiary designations per your wishes, even if your children are beneficiaries under your will and trust. Teaching point. The beneficiary designations on file with the retirement plan administrator trump any contrary arguments in your will and trust. In fact, the U.S. Supreme Court has ruled that, despite any state law to the contrary, your ex-spouse will inherit your 401k if he or she is the last designated beneficiary on file with the plan administrator. IRAs are governed by state law, and that, by and large, makes them more pliable. Without the inflexibility of the ERISA laws, when it comes to your IRA, it's all about the named beneficiary, unless there is a state law to the contrary. One thing remains consistent, however. Beneficiary on file with the plan administrator takes precedent over any provisions under your will or trust. Exceptions. Some state laws rule out the complete disinheritance of a spouse, and some have laws automatically disinheriting an ex-spouse as beneficiary, unless you've completed the extra paperwork to confirm your intent to include your ex-spouse as beneficiary. I discuss beneficiary designations on my website, especially the video 3 Ways to Avoid Probate Without an Attorney. The video is free, but you must enter your email to view it. Bottom line, if you're concerned about a New York asset protection, then retirement accounts, whether 401ks or IRAs, are important assets for any Americans. Given the complex tangle of laws that control your options, it is essential that you consult with a competent legal counsel and coordinate the distribution of your retirement accounts as part of your overall estate plan. Be sure to consult an estate planning attorney admitted in your state of residence, as state property laws may need to be reevaluated as well. This is David Parker with the Law Office of David Parker, and another entry on my video blog. Joint ownership, hidden pitfalls to avoid. One of the most common estate planning mistakes that people make is joint ownership. Estate planning can be daunting. Once you get past the fact that your very mortality and morbidity is the triggering event, estate planning means taking stock of all you own,